Hello, everyone. Thank you so much for joining us from all over the world in different time zones. Um, this is the launch event of the special 20th anniversary of the Socio-Legal Review. My name is Manhar Bansal, and I was the editor-in-chief of SLR for the academic year 2023-24 and in charge of volume 20 of the journal. I'm joined today by Divya Sethuraman, a fellow editor from the 2023-24 editorial board and the current deputy editor-in-chief journal. For those of you who are new to SLR, I'll just briefly introduce the journal. Socio-Legal Review is a peer-reviewed biannual journal that encourages interdisciplinary research at the intersections of law and social sciences. We are an open access student-run journal published by the National Law School of India, University, Bangalore, India. SLR was first published in 2005 by a group of students at NLSIU in the backdrop of the law and society movement and the growing realization that law cannot be understood divorced from social and political realities. In 2025, we celebrate the successful completion of 20 years of this bold attempt. We thought that this was a long enough time to take stock of how far we have come and what lies ahead. And this special issue, titled SLR at 20, Reflections from India, South Asia, and Beyond, is an attempt in this direction. And I'm very delighted to say that to celebrate the launch of the special issue, we have with us today authors of 4 of the 5 articles that comprise this issue. And I'll quickly introduce all of them. Dr. Elizabeth Lhost is the program manager for the Modern Endangered Archives program at the UCLA Library in the US. She's a historian of modern South Asia, working at the intersections of legal studies, social history, and critical archival studies. And she's contributed an article titled Fingerprints and Fragments on social legal history in South Asia. And I must mention that she's taken up the time to join us at 5:30 a.m. In Eastern Time, USA. So thank you very much, Dr. Lhost, for joining us today. We have next Dr. Anup Surendranath and Ms. Maitreyi Misra. Dr. Surendranath is Professor of Law and Executive Director of the Square Circle Clinic, formerly Project 39A, at the NALSAR University of Law, Hyderabad. Ms. Misra is Director, Death Penalty Mitigation, and also Director, Mental Health and Criminal Justice at the Square Circle Clinic. Their work at the Square Circle Clinic, formerly Project 39A, needs no introduction to this audience. But for those of you who are unaware, the clinic undertakes pro bono criminal defense of prisoners sentenced to death in India, along with research and public engagement efforts on diverse issues of the criminal justice system. Thank you so much both for joining us. We are happy to welcome next Dr. Mariam S. Khan, a socio-legal scholar on South Asia and a resident research fellow at the Institute of Development and Economic Alternatives at Lahore, Pakistan. Dr. Khan's contribution to the special issue examines the socio-legal question in South Asia through a comparative and historical lens of socio-legal studies in Pakistan in broad comparison to India. Thank you, Dr. Khan, for your presence today. And last but not least, we have with us Dr. Sarah Desilets, Professor of International Law and International Relations at the European School of Social and Political Sciences, Université Catholique de Lille, France. Dr. Desilets' research revisits the long history of extraction between the African continent and global capitalism since the 19th century, a glimpse of which she presents in her contribution to this issue from a social legal lens. I also want to take this opportunity to mention that included in the special issue is a wonderful article on legal anthropology in India, authored by Dr. Deepa and her student Janvi Jamathi from Emory University. But unfortunately, they couldn't join us today for this event due to other commitments. And of course, our issue is book-ended by an intimately written postscript by Kalyani Ramnath, a legal historian and an alumni of the National Law School, and one of the earliest editors-in-chief of the Socio-Legal Review. With the introductions done, we can now move to the roundtable discussion, and I'll hand it over to Divya.
Hi, everyone. Thanks again for joining us today. So in terms of format for the roundtable, we prepared a few questions that pertain to the contours of social legal scholarship today. And we have a first question that is directed to all of you authors, and then separate questions for each of you as well. I'd like to take this opportunity to mention that for all of the attendees of the conference, there is a Q&A button on your Teams screen. So please feel free to type in your questions during or after the interview. When we open the floor for audience questions, Manar and I will recognize the questions and call on you to address it to the authors on the panel. So I hope that was clear and I'm audible, Manar. Yeah. So beginning with the first question for all of our authors. So we wanted to ask you what socio-legal means for each of you, and specifically, how does your contribution speak to this theme in the volume? And if you could elaborate a little bit more on what is your vantage point in approaching this question. So if we could begin with Dr. Elizabeth, and all of you could in turn sort of answer the question.
Yeah, thank you. And thank you so much for organizing this event, for being editors of this volume, and for really doing the work to take stock of what the field is, who's in the field, what sort of questions they're investigating, and how the field has kind of developed and emerged over the years. For me, the question of what is social legal is a really complicated one, but it's one that as a historian always comes down to sources. When I think about the types of work in the field that have been most influential to me, have been most inspirational to me, they're always the ones that come from a really rich historical archive. They're the ones that are written by the historians who are going into collections that nobody has worked with before, or nobody has worked with from a legal historical angle. And they go in there and they start to figure out what's going on in the archive. Because one of the things that I find thinking about the question of what is the social legal is how many ways it kind of touches upon different questions. It touches upon different disciplines, as I think our conversation will move into at some point. And it touches upon really the fundamental question of what is law and how does law operate. And one of the things for me that I find so compelling about these studies that are based in really rich archives is that people are looking at not only what's happening within courts, they're looking at not only what's happening within legislatures, but they're looking at how those institutions are also intersecting with changes in social context, intersecting with different groups of people, maybe privileging some groups of people, disadvantaging other groups of people. They're looking at how professionals and non-professionals are moving through those spaces and are really thinking about the institutions that surround law as being embedded within social context. So these are institutions that not only change over time, but they're also institutions that have different authorities and have different places in society, depending on when we're looking at them. And so for me, as a historian, the archives are always present. I think that's clear in my piece, that I'm always thinking about what archives are doing and how we can use archives. And they're the ones that have archives that allow us to then ask those questions about what is happening outside of the courts that we don't see from those archives, and what is happening within those courts where some of the activity from outside of the courts is being refracted in different ways, interpreted in different ways, and recorded in different ways. I know we have quite a few contributors here, so I'll just leave it there for now.
So Dr. Mariam, if you would like to.
Yes, sure. I just want to once again, like Elizabeth, start with a quick word of thanks to the Socio-Legal Review and its editors and its team for putting this conference together, but also for putting together the special anniversary issue and for enabling this really important cross-border conversation, given that, we hardly, as South Asianists, get to speak sitting in our various sort of spaces within and outside of South Asia. So this is really important to me, especially at this moment when all we can see around us is hate, vitriol, and conflict and hostility. So thank you so much for this wonderful and really important forum. So my vantage point, I have to say that the work that I did for this issue is narrower than all the other contributions in one sense, in the sense that it's more of a country study on Pakistan. It's a survey piece, trying to think deeply about how socio-legal emerges in that context. But I think it's broader in the sense that it's also using Pakistan as a kind of a generative case study for a broader question, which is to say, how does context shape what is socio-legal, and how does then in turn the sort of evolving socio-legal loop back into what the contextual conditions are for knowledge generation broadly. And so, I mean, I'm going to quite deliberately evade any direct answer to the question of what does socio-legal mean to me. But what I want to say is that I think what I've tried to do is really to say that this is such a deeply contextual question, which is not to assert any kind of exceptionalism, but which is really to kind of emphasize that we need to interrogate questions of, conditions of power, conditions of knowledge generation, spaces of knowledge generation broadly in terms of, state making, nation building, these large sort of, processes, and what that does to our understanding and meaning making around the socio-legal, and what are the kinds of different sites that we can identify that feed into this and then sort of feed back into all those other sort of spaces that we typically don't consider to be sites of law or sort of legal meaning making. So context was like the big sort of anchoring point for me. And I also wanted to say one quick thing about how, it was a welcome sort of, I think, provocation from the social legal review to think about perhaps a South Asian approach to the social legal. And I think it really made me think deeply about, is there really such an approach? Can we really dismiss this question outright? Is it something which is too cliched? Is everything, can everything just be differentiated across the region? I mean, India and Pakistan and Bangladesh, of course, share a colonial ancestry, but is that really sufficient to talk about a South Asian approach? And I think ultimately I came to the conclusion that just like India has historically and even in contemporary times been very dominant and continues to hold a position of privilege in what socio-legal in South Asia means, it was also unfair to assert any such thing through the lens of Pakistan. So I completely eschew the South Asian approach to say, well, is there a way of understanding an approach from our region which can be differentiated across context, really interrogating questions of power and marginality and all of that. So I'm going to stop there, but happy to take further questions.
Thank you so much. We'll come back to the cross-border question. That's a question we have prepared for today. But Dr. Desiree, would you like to speak? Dr. Mariam's response touched upon how thinking of a social legal approach, a South Asian approach to social legal, might come with its own dangers. And in your contribution, you look at how can we examine this question globally. So would you like to go next?
Yes, thank you very much, Manhar. And let me also use this opportunity to thank you particularly and your team for putting together this special issue with a lot of professionalism and kindness, may I say. It was like, for me, it was a pleasure to receive feedback both from peer reviewers and from student reviewers, as I understand. And this is a great specificity of the journal. And it was a very enriching experience for me to just try to, because writing is also about translation and cultural translation in many ways. So to get your words understood across the board, and not only by peer reviewers who may be the closest to what you're studying is good, because it's a way to learn as well. So it was a learning experience for me too. So thank you first. So may I pick this question from a personal angle that may be something that is shared by a lot of you. As most of you studying at the university in India, you probably feel that you're go-betweens already between law and social sciences generally. It is the case for me too, but hailing from a French background where there is a very clear and deep-cut divide between law and the social sciences. And it's changed, of course, more recently. But when I was studying, law was definitely not politics, and social sciences were definitely not about law. So there was this struggle that still exists about what does it mean to open the black box of social sciences for legal scholars and vice versa. The way I consider myself is as a middler, someone who's neither in nor out. And I've applied this throughout in my own professional trajectory. I'm a lawyer in a political science department, but I'm a political science scholar for lawyers. This is a vantage point that can be deeply uncomfortable from an institutional point of view, but from a knowledge point of view, it can open a wealth of avenues. Because to some extent, it has allowed me to act as an intermediary. That is, by bringing into focus flows and counterflows between law and social sciences. And this brings me to the contribution that I built for the special issue. So I was asked to reflect on what is global about socio-legal studies and how do we think about the global from the vantage point of a social legal inquiry. It was a difficult question for me. So I eschewed it in many ways by saying, okay, let's change the focus and let's ask this question from the South, but from a South that's remote, both from a Western European focus and from a South Asia focus, by looking at it from a site that is seen in contradictory terms, both as an exceptional site because it's super violent, but also as a site which is hyper legal. And I'm talking about one particular site in the African South called the Democratic Republic of Congo, where most of the minerals used for the green transition can be found, and I'm thinking of cobalt in particular, but which is widely seen as a legal vacuum in need of constant legal reforms that are constantly failing. So my piece aimed at pushing against scholarly boundaries to escape the trope of determinism, particularly the protractedness of the subaltern position of the African South in scholarly debates and policy change. But this case study was also a way to push against the global as a heuristic category and as an empirical reality, by saying that the global is basically what we think it is. That is, it is made up in my own approach as a mix, an entanglement of localities that are deeply related to colonial and imperial legacies. And this will bring me probably to the cross-border question that we will address later on. Thank you for now.
Thank you so much for that, Dr. Desley. So I think we'd also like to hear from Dr. Anup and Maitreyi ma'am as well, because I think their contribution on mitigation and death penalty really bridges the theory practice question when we look at social legal. So.
Yeah, so thanks everybody at the Social Legal Review for having us contribute to this, and apologies for all the difficult times we gave you with all the delay from our end. As I noted in our email exchange, it was absolutely great to see the student feedback and how it's, and in many ways we felt that the quality of the student feedback was far superior to that of the peer review feedback, right? So great work. Thank you so much for putting this together. Yeah, so I'll let Maitreyi talk about the mitigation investigations part of it, but very quickly to say that as far as the socio-legal and criminal law is concerned, I think it's one of those fields that has been subject to that socio-legal critique in many ways, and it's quite an there's rather expansive field of socio-legal critique to criminal law in its research, be it from the critical race theorists or critical legal studies or caste critiques or feminist critiques, and I think and as far as our own context of South Asia is concerned, or the global South more broadly, I think criminal law faces a rather particular challenge in terms of theorizing around criminal law is sort of so centered around Euro-American legal systems. And in that sense, Southern criminology is something that is only starting to have that influence, and is not something that has entered thinking of criminal law. I mean, I can speak to the Indian context, that the Southern criminology perspectives is something that work remains to be done as far as research on criminal law and the critique of criminal law in our context is concerned. So I recognize that broader field operating as far as criminal law is concerned, but our particular interest is what happens to this socio-legal perspective when translated into actual criminal law adjudication, right? And that's where we come in. It's that when we represent prisoners sentenced to death, and the court is looking at constructions of criminality, of extreme culpability, as the courts here call it, to say that, okay, we need to choose a bunch of people who we can execute, right? And not everyone who commits X crimes can be executed. So from that bunch, we need to select a few, right? And in that selection, there is a certain construction and imagination of criminality. And our challenge has been that legal determination, while the law wants a certain kinds of specificity and answering a very deterministic question, nonetheless, the law is entirely dependent on interdisciplinary socio-legal perspectives to understand the individual that it is trying to decide whether that person must be executed or not. And that poses, and I think the challenges are much more pronounced when it comes to actual practice and determination, because it forces persons of the law, and it's quite dangerous, I would submit to sort of this audience, to have persons of the law take these socio-legal perspectives or scientific legal perspectives, even when it comes to psychology and psychiatry, right? And try and answer a legal question, and answer a concrete legal question in an adjudicatory context. And our piece has been to look at those challenges, while there has been the broader critique, theoretical critique of criminal law from socio-legal perspectives. I think the challenges are very different when you apply that socio-legal critique to criminal law adjudication as a space. And the piece examines that, and in the context of investigating the lives of death row prisoners and presenting it before a legal forum, it gives rise to very, very particular challenges. And it has much to say about the limitations of both the legal process and also of what questions interdisciplinary perspectives can answer for the law, right? And it speaks to limitations on both fronts. And I'll let Maitreyi sort of elucidate that further.
Thanks, Anup. I also wanted to echo all of the authors in thanking the editorial board, especially Manhar, in putting together what I thought was an extremely thoughtful collection of topics and just like an overall very, very thoughtful issue. So thank you. And yeah, thanks for giving us the opportunity to talk about a very nascent and niche area of criminal law from an interdisciplinary perspective, which is both the idea of sentencing in criminal law, but also how do we go about sentencing within the framework that we have set ourselves in the death penalty context. But before I just go there, just quickly about what I think, particularly in the context of criminal law and sentencing, socio-legal is both a methodology, but also sort of um, a bridge and an insistence, right? That the law is legal fiction, and socio-legal approaches allow us to drag reality back into law and the fiction that law often deals with, which is, and one of those fictions and central to criminal law perhaps is the idea of an individual, right? Criminal law deals so much with who is an individual and who is worthy to be, who is deserving of punishment, who is deserving of guilt, and who is deserving of certain other statuses. But what we found in our practice and what we talk about in the paper is our practice of death penalty mitigation and conducting mitigation investigations in criminal cases and death penalty cases. And what we found, I think, is, and that's where the bridge and the sort of the bridge forcing the social into the law kind of comes into play, is the idea of the individual that criminal law has, which is in itself very broad, undefined. Uh, One would almost argue archaic and unscientific, uh, is very different from what you see when you go and look actually at people who have been made subjects of criminal law, which is in death penalty cases would be people who've been sentenced to death or are at risk of being sentenced to death. And I think what we found in our practice is that there is a whole life history of an individual that the social allows us to investigate, that the law would never allow us to investigate that social, that life history of the person, even as the law sets out its, in India, in capital cases, it sets out its task as a social legal task. But the law is deficient in imagining and also understanding who this person is, who it's punishing, or who the subject of that particular sentencing exercise might be. And in our practice of mitigation, where we look at different social sciences, psychology, sociology, psychiatry, anthropology, criminology, and we borrow from all of these streams and streams of thought and academia to construct that individual, because an individual is not a unidimensional person as the law might like to imagine. It is embodying multiple systems, multiple structures, multiple contexts, and it is the social which allows us to understand that individual. But the moment that social starts hitting against um, the neatness of the law, or that the law really desires, the cut and dryness of the law, it starts to kind of warp the law as well. And that is what we are seeing happening in our courts, where the law is currently, as it currently stands in capital cases, unable to really deal with the complexity that the social brings to the law, and that the social and the complexity that socio-legal is. And in our it is the work that we've done as mitigators and in developing the mitigation practice that we've managed to really, I think, get legal actors to confront with the lofty imagination that sentencing must be a social legal exercise. What does that actually look like? And what complexities and warps arise because of that? So I'll just stop here and yeah.
Thank you so much, everyone, for all your insights. So for the next set of questions, what we thought was we had some specific questions from each of the authors based on their contributions, but of course, others can jump in. So please feel free to unmute or raise your hand because we want this segment to be more of a conversation, and we also want to make sure we leave time for audience questions. So maybe we can keep the responses a little shorter. So as everyone said, defining the social legal is a very complex task. And one of the things we wanted to do with the special issue was to see also how SLR has specifically understood social legal. And what we did, and this is what I do in my editorial, is that go through all the past editorials of the last 20 years and see how different student editors in conversation with their authors have understood this question. And a kind of tentative framework we came up with is that, at least as far as SLR is concerned, we have understood social legal across three axes of discipline, subject matter, and methodology. And we do think that these three axes are kind of reflected in the contributions to this special issue. So if I could begin with Dr. Lhost, in your contribution, you speak about how the history and the institutional kind of history of legal history as a discipline also influences the methodology and the boundaries and the questions that are possible to be asked using a social legal lens. And this is something I noted Dr. Desile also said in her response today when she talked about how the disciplinary organization of universities and faculties in different countries vary. So would you like to speak to that, how you think institutional histories and design also influences the way we understand this particular area of study?
Yeah, I think that's a really interesting question. You know, one of the things that kind of keeps resonating in my mind is a comment that somebody made to me when I was first starting to get into legal history and first starting to identify as a legal historian. And somebody said to me, that would be great. It would be great if somebody would write a proper legal history of British India. And at the time, I was sort of like, okay, yeah, that's not really what I'm doing. But it sort of stuck in my head, this question of what is a proper legal history, or what is a legal history? And when I first started thinking about what I was going to write for my contribution to this issue, I had in mind a very straightforward contribution. I was going to say a little bit about what socio-legal history has done for the study of South Asia, and I was going to say something about what South Asia has done for the study of socio-legal history. And I realized as I started to think about those themes and as I started to reflect on them, that I couldn't really I couldn't write that piece because that would not capture everything that I thought went into socio-legal history. And so I think in the way that I've thought about the field, there are some subjects that are kind of recurring topics. So we have, you know, the histories of imperialism and colonialism, we have decolonization, we have some of the questions on caste and social structure that continue to reverberate throughout the scholarship. We have some discussion of the relationship between, say, the urban and the rural, or between the sort of presidency towns and their hinterlands. We have questions of what's happening in Britain and what's happening in South Asia throughout the colonial period. But even in terms of subject, there's so much else that can be discussed. And I think the contributions to this volume speak to this, but I also think the field of legal history speaks to this in the sense that people are continuing to, and I think this is really true in the last 20 years or so since this journal has been around, really starting to consider different angles of legal history. So if I had to guess what I think this person in grad school thought a proper legal history might be, I think it would be kind of a history of law and legislation. It might be the histories of you know, the Macaulays and their visions of law. And it would not be what I think sort of my predecessors and also my generation of legal historians are doing, which is what and Maitreyi, I'm gonna bring your what you said here. It would not be the type of history that drags reality back into the law. It would be the type of history that kind of takes that Londoner perspective and says, this is what the law says on the book, so obviously that's what's happening in South Asia. And the way that many of us have started to reconceptualize or rethink law in South Asia is really to think about what happens when that idea of law crashes into the social realities of what's happening, not just in South Asia, but also in the world.
Thank you so much. I wonder if anyone else has a response to that. I was wondering, as Dr. Elizabeth was speaking, that even when Dr. Mariam's piece was being reviewed and we were having conversations, I think this is a question which did come up of struggling to write a piece on which is properly either granularly historical, but also comparative, but also socio-legal, but also South Asian. And that is a struggle which I think was productive. Dr. Khan, if you have any comments, or else we can also move ahead.
Yeah, sure. I just want to say yes. I mean, that was a lot of grappling. And I think at one point I stopped intellectualizing everything and I just said, let me just write this organically and see what comes out. It was impossible really to make sense of for a better part of the time I spent writing this. But I just want to add one thing, which is to say, of course, discipline, subject, and method. These three prongs really have a very intimate connection in the way that socio-legal evolves. But I also want to say that, Pakistan's trajectory will show you, and this is a phrase that I think Kalyani uses in her postscript. The socio-legal in Pakistan has been a very indisciplined inquiry, in the sense that what we would all understand as socio-legal is a fairly recent phenomenon. So, you would have to really dig deep into lots of other disciplines, most of them coming from an outside gaze, particularly American and British, to some extent, political scientists who really were constitutive of the field of public law, at least in the first 25 years of writing on constitutional politics in Pakistan. So public law is like an enormously sort of prominent and generative field. And even when the production of socio-legal knowledge becomes more coherent and more institutionalized within the legal academy in the early 2000s, it really tends, initially at least, to replicate, I think, a lot of continuities in subject matter and method that already existed back in the 50s, 60s, 70s, 80s, and 90s. Interestingly, and to the extent that, a lot of questions which are being asked, or a lot of subjects that are being privileged, are really more refined, let's say, versions of the prototypes in the earlier decades, constitutional law and politics being high constitutional law and politics being one of them, Islamic law being another. And so I think it's only recently that we've begun to see some diversification in terms of the questions we're asking, in terms of the phenomena that we are critically assessing, and in terms of the methods that we're deploying or pluralizing at this stage. And I think that one example would be legal history. I cannot actually point to any real, I think, example of legal history till very sort of recently. And that too comes on the heels of how history is now being written in the past 2 decades. And of course, there's some osmosis there. But for instance, one can point to bodies of literature on legal history and constitutional history in India that also engage with the question of colonial history in Pakistan that has been mostly non-existent. And to that extent, the comparative lens with India for me was really helpful, because as I was trying to make sense of it, because really I felt like I was looking at a vacuum and didn't really know what my point of departure was. So I'm going to stop there, but I think there is all this institutional influence, but I think a lot of it also tends to at least initially replicate what is already there. And so you do see a lot of those continuities.
So our next question was for Dr. Desley. So if I might preface the question, and then you can also comment on the conversation that we're having, and then we can move on to Dr. Anup as well. So I think Dr. Anup had mentioned in his introductory comments how much criminal law has been subject to the socio-legal lens. And Dr. Mariam also talked about how the question of socio-legal is quite tied into the idea of public law. But Dr. Leslie, in your contribution, you applied this socio-legal lens to say private contracts or regulation in the field of the global value chain for COBOL, which are often sort of bracketed as a private law in the domain of private law. So we wanted to ask you, what do you think is the value of the socio-legal lens in this kind of slightly newer subject matter that you are dealing with in your piece, unlike, say, criminal law or public law? And then after that, you could also comment on the conversation we have.
Thank you. Thank you very much, Divya, for your question. I think your question actually is very tightly related and connected to the responses that were provided right before by Mariam and Elizabeth. Indeed, let's say Elizabeth was asked to write the proper book, Legal History on India, and I started my PhD at a time when international relations scholars were asked to write the proper book about conflict resolution and alternative dispute resolution in Africa, because Africa was like, and when I say Africa, it's like this big policy term. Africa was seen as a new bed and laboratory of violence and conflict resolution. Once you take a step back, both on institutions and your own knowledge trajectory, you stumble very rapidly on a problem. Not only is there no proper book, like for some countries even, conflict resolution or transitional justice has proven to be a massive and to some extent scandalous failure, like in Burundi, for instance, or even in the DRC to some extent. But you also stumble on the question of archives. And in this issue, the question of archives is not so much their scarcity, but it's something that we could call the problem of scattered knowledge. If I take the example again of African settings, there is no comparatively similar example as for the Raj and all the legal frameworks and the legal histories that surrounded the Raj. But on the African continent, there was a wealth of legal scholarship that was deeply socio-legal during the colonial era. Why? Because legal scholarship in this understanding of its socio-legal leaning aimed at disciplining peoples and bodies. And it is very interesting to see institutional legacies in this, taking the example of France, but also of Belgium as a former colonial metropole, in the way that ADR and conflict resolution as applied to former African colonies is very much about this disciplining bodies and peoples. Whereas the question of products, like cobalt and others, has been very much related to an offshoring of discipline, because it's been embedded in international private law. So here we have a disjuncture that is both institutional and about disciplines. And in my own trajectory, and including for that paper, this has led me to seek to question seriously what Georges Steinmetz and others who belong to the so-called global turn in sociology and the social sciences more generally called the imperial entanglement of disciplines. And by taking this seriously, for me, meant saying, what if we stop looking at sites that are conveyed and construed as exceptional? What if we stop doing that and instead look at them as structurally banal? And once we do that, what does it tell us about law on the one hand and society on the other? Which means that for me, being a socio-legal scholar it's a very difficult definition, right? But it's more about being a seismologist, someone who is not completely afraid of chaos and pushing against boundaries. But I'll stop there for now. Thank you.
Yeah, thank you. Professor Anup, I see your hand, but we also had a question, so maybe we could combine your response with the question. Um, Pr- Dr. Sara ended by talking about boundaries, and one of the boundaries which SLR has been concerned with is also the boundary between theory and practice. And that also speaks to the question of methodology. We talked a little bit about discipline with Dr. Lhost and subject matter with the private law conversation. Methodology is another kind of key concern that SLR has considered. And the question was that, and I have personally interned at Project 39A as a second year student, and I've seen the demands of work and time that exist for you in legal representation for prisoners from death row, etc. And still, why do you take out the time to write for a scholarly audience? What is the value you see of theorizing the practice that you do, and how do you see the relationship between the two? Yeah, Dr. Anup.
Yeah, well, the short answer is, Manar, you asked and we couldn't say no, right? So no, but more seriously, I think the point I wanted to make was on methodology, and that's why I also wanted to raise my hand. It's amazing how in practice, in the field that we are talking about, that where the law requires you to carry out an investigation, a socio-legal investigation into a convict's life history and culpability, how there is no conversation of methodology there. The law is, in its practice on this, completely silent on methodology, right? Either for the prosecution or for the defense, there are no boundaries in that sense, right? There is no legitimate or correct way or signpost by which this socio-legal inquiry must be carried out, right? Neither in the US or where the sort of mitigation investigation history is there, or even in India, I think this methodological silence is almost deliberate, right? It allows the law to reject the socio-legal inquiry in cases that it does not think we should take into account. And I think cases involving terrorism is a perfect example of this, right? Or cases involving child rape and murder, right? And I think it leaves courts open to say, there are times where they will consider that, and there are times where they will just reject it. And nobody knows how legitimate this information being gathered and produced is. And I think a lot of it, the law, in a best case scenario, assumes that the adversarial system will account for this silence, right? That either if they feel that the defense is overstretching this, or the prosecution will step in. But I think more than I think this complete lack of engagement that we see with methodology is rather deliberate and is dangerous in a system, right? And you almost, I think the thing to think about is, would you then rather not have an adjudicatory system pretend to go into a socio-legal inquiry, right? If it is only to reject it at its convenience, right? And in terms of the question of why do we write for a scholarly audience, I think that there isn't enough conversation between, in that sense, scholarly research and writing and practice, right? There is almost in our system a sort of a mutual disdain in either direction, and it leaves, it adversely affects both in that sense, right? And scholars feel that litigation and the actual realities of practice and courtroom procedures is in our systems just too haphazard. You can't make sense of it. Access is a big problem, and of course practitioners have a certain view of academic writing, right? But I think unless some of these foundational questions are explored and spoken about, that those silences in the courtroom are not going to be challenged, right? And for us, it is a method to challenge that silence, because these are conversations we cannot start in the courtroom. These are conversations that need to start elsewhere and then be transplanted into the courtroom.
Yeah, thank you for that. Before I come to Maitreyi ma'am, another interesting thing about the divide between theory and practice is that lately we've seen co-authored pieces in SLR written by a pair where usually one person is more of an academic and the other person is a practitioner. And if we can say that, from what I understand, I mean, I know Professor Anup also, you teach at a university, whereas I think Maitreyi ma'am is more on the kind of the nuts and bolts of the mitigation side of things. So I was wondering if that also plays a part in how you write and how kind of co-authorship works, etc. Maitreyi ma'am?
Yeah, before I just respond, I wanted to connect something that Sarah said about chaos and Anup's point on methodological silences in law. And I think while Sarah was talking and while Anup was talking, what I was thinking is that even the socio-legal inquiry, right, that the law has set for itself, it's looking at that social-legal inquiry as as if it is in the nature of a legal inquiry. It's not actually looking at it as a social legal inquiry. It wants it to be a legal inquiry, but it's characterizing it as social legal. And because there is also um, uh, maybe hierarchy is not the right word, but that's what I'm going to use now. There's a hierarchy of disciplines that the law likes to rely on, particularly criminal law, right? Psychiatry, for instance, because you'll see in criminal law, whether in courtrooms or in theory, like let's say the insanity defense, psychiatry is given a lot of prominence. But sociology will not be given that prominence because sociology is deeply chaotic. It's not going to give you easy, straightforward answers like psychiatry would, like law wants itself to give those answers, right? So the methodology that it wants and actually what it wants are also, there's a stated methodology and there is a unstated approach to that methodology, and the unstated approach is make it more legal, make it a legal inquiry, but I'll call it social legal. So I just wanted to yeah, just connect those 2 points. In terms of the practice of mitigation and how that has sort of um, corresponded or interacted with the theory. I think it's what it has allowed us to do is to develop a theory based on actual evidence, right? It's the mitigation investigations that we conduct, that we've been conducting over 100, over 100 cases, I think. It is also collecting evidence on what is happening in the ground. Why does crime happen? Uh, why do certain people get sort of captured by the law and by criminal law, and certain others don't? We are also building evidence for to develop theory, right? So and this is something that we've sort of tried and done, let's say, in trying and providing contours to legal principles that we in India rely on in death penalty sentencing, which culpability and reformation, right? Our understanding of culpability or extreme culpability for the purposes of punishment is based more on what we have seen on the ground, what life histories we've been able to gather, how they may have corresponded with violence, than a theory of culpability or theory of blameworthiness, which is grounded only in sort of a vacuum. Yeah, it's grounded in vacuum, not in reality. You to use that practice and gain that evidence to then form new theories and maybe more informed theories rather than vacuum theories which get built in vacuum and have no relationship to how things really work. Yeah, I'll stop there.
Manhar, can I just make a quick
Professor
point?
Anup, did you have something to say?
Yeah. No,
Sure,
I
go
just
ahead.
wanted to
Go ahead.
very briefly just say, in our practice, I think we also need to reflect, is theory useful at all when I'm going to construct this life history of an individual and try and make a case that this person should not be hanged to death. I'm wondering what use is theory at all in such a context. One almost senses from the court hearings we've been involved in that emotion works a lot better, right? Right? That the theoretical framing of someone's life history seems to work a lot less than I know some, and it's always amazing what a few sentences in that mitigation investigation report appeals to what judge, and it forces you to think whether emotion is a better framework to think this in.
Yeah, but I would just say, I guess we could also theorize law and emotion. I mean, the SLR forum had a series on law and emotion where we kind of investigated this question with Professor Susan Bandis, who has written about the role of emotion in victim impact statements in the United States and all of that. So yeah, I'm going to say, I guess, defend theory. But yeah, Divya, I think, had the last question. Divya?
Yeah, so I think this goes back to what Dr. Mariam said initially in the introduction. So she spoke about how, despite having quite a shared history, we don't really have cross-border conversations, even in social legal scholarship, when it comes to India, Pakistan, and Bangladesh. So even if you look at our own history of publication at SLR, most of our articles are focused on India, although our mandate itself says that we're looking at social legal scholarship in South Asia. So I think with the special anniversary issue, we try to do some justice to our own mandate, and we specifically wanted to invite a contribution from Dr. Mariam. So addressing this question to you, though you touched upon this a little bit in the introduction, what do you think is the value of these kind of cross-border conversations, especially when it comes to social legal work?
Thank you so much, Divya. And yeah, I mean, if you ask me, could I have written the piece that I did without, having my gaze on developments in India? And my answer would be, and I think that mirrors a lot of what goes on across our, legal institutions as well, in the sense that you will find that Pakistan, in many forums, not just constitutional law forums, still relies quite heavily on Indian jurisprudence. And so we've had this osmosis for such a long time, and I think it would be near impossible for, at least in my capacity as a researcher or a scholar, to really understand the social legal in Pakistan without first understanding the social legal in India, and then from there sort of using that as a point of departure. But I don't necessarily want to reduce this cross-border cross-fertilization to, the concept of a foil. So it's not just that, India is a foil for Pakistan or vice versa, but I do want to say that that intra-regional comparison or conversation is really productive and generative in so many ways. So, why is it that we have been asking the questions that we have? And what are the questions that we're still not asking? Why is it that India at least has a tradition of interrogating questions from the lens of the subaltern, and Pakistan hasn't even scratched the surface of that inquiry? Why is it that we are so focused predominantly on the post-colonial state, acting as if it's segregated from the question of coloniality, so on and so forth? And I think that those sorts of really productive exchanges only come about through cross-border conversations. And I think Indian scholars or scholars on India would be better able to say how the rest of the region contributes to their understanding of South Asia, the social legal in South Asia. But for me, I mean, very clearly, I think that much as one, sort of complains about India being the intellectual hegemon in this conversation, I think there is a lot also to be taken away from that in a positive way, in trying to understand our own, contexts, which are of course bound in so many ways, but are also diverging in so many ways.
Thank you so much, Dr. Khan. So I see that we're already at 4 Indian time, and I know that everyone's taken on time, but is it okay if we take about 15 minutes more, because we do want to have audience questions, and I think the conversation is going really well. We only have one question from our end, in case, unless someone has a comment to make on this last question. All right. So the last question I had was that, so the way when we were conceptualizing the special issue, we kind of wanted to do like a review issue where we were thinking about, okay, let's take stock of what socio-legal means, etc. But then we looked at other journals and the models they have followed for review issues, and we decided that we didn't want a curation which was just all short review essays. So we kind of came up with this model where we asked authors to write full-length research articles for any other issue, as they would write for any other journal publication. From their vantage point, pick up a topic, but then also address the central question, which is like the taking stock of the field. And I was wondering if any of you had any comments to make on that. Did you think this was useful, and what do you see is the value of these kind of periodic review issues, but also not those short kind of off the cuff 5 pages of kind of summarizing the field? Yeah, not everyone has to respond, but in case anyone has any thoughts, we can take them. Right, I don't see any hands. Yeah, sure. Dr. Lhost, go ahead.
Yeah, I'll get us start with this question. I think one of the things I found myself thinking about while writing my contribution for this issue was the question of not only what the field has done so far, but what the field has yet to do. And so one of the things I wanted to voice in my piece, and maybe I toned down some of the language for the actual piece, is some of the frustrations that comes from kind of approaches that haven't been taken, paths that have not been explored yet, and some of the sort of, oops, I think I'm messing up my teams here. Some of the like avenues that people haven't yet explored. And what I wanted to do in my piece was both to reflect on how far the field has come in the past 20 years. We've had so much scholarship in the field of legal history, and every time I meet with new graduate students who are starting their PhDs or starting graduate programs, I'm amazed by how many of them are so confidently interested in law or in legal history, because when I was working on this, it was still kind of a fringe area. There were definitely people who were doing scholarship. Some of my mentors and fellow students, sort of cohort mates, were doing some work in this area, but it was still kind of new and people were still kind of skeptical of it, or they still hadn't quite embraced it. And now it seems like a lot of everyone is doing legal something, legal history, legal anthropology, legal sociology, something along those lines. But I think in the work that people have done, it's really easy to fall back into some of the older approaches to the field that maybe weren't problematizing the question of what is law, or who controls law, or how law works, or what are the institutions where we find law, and to return to not only some of those older approaches that I think have a really big imperial and colonial inheritance to them, but also to, as more people enter the field, to start to define what the field is more rigidly and start to draw some more boundaries around the field. And part of what I wanted to do in my piece was to kind of make a provocation to say that even though we've had so much new scholarship in the field, there's still a lot of work to be done. And there's still a lot of other ways, a lot of other topics, a lot of other areas that people can explore within this field. And we all need to be working in those areas, and we all need to be kind of pushing the boundaries farther and farther open, and opening up new questions within the field to keep things going and to continue to push back against some of the questions of power and oppression and dominance and things that I think run through a lot of the scholarship.
Okay, thank you so much. Okay, we can take quick responses from Dr. Sara and then Maitreyi ma'am, and then we'll move to audience Q&A quickly.
Thank you, Manhar. And just very quickly, because I totally agree with what Elizabeth just said, like for a scholar, a journal or a discipline itself, a journal like an institution, there is necessarily, as time goes by, especially on the anniversary of the 20th anniversary, just the tension between innovation and normalization. And it's a little bit what just like what Mariam said about subaltern studies, like when does it come something that is so routine that you feel that you can't depart from it, or you feel that you have to treat it as a vacuum because you need to innovate. So it's a tension that needs to be carefully managed and navigated, and I think that the strategy that you used was absolutely the right one. That rather than taking stock of a discipline as if that discipline had finite boundaries, it was better to just throw questions and then see where they landed, to treat socio-legal scholarship and the journal itself as something that can be much more flexible, much more malleable. And your the prologue was very good in doing that, in also saying that each student, editor, and team has their own say in how they see the journal, where they want to bring it, and this changes every year and brings dynamism to the journal.
Yeah, just quickly to add to what Sarah and Elizabeth have said, I think going the way that you guys decided to go with the review also allowed people like, say, Anup and I, who are at the intersection of theory and practice, to put our heads together and review what we have done, right? What is practice showing us? And just the long history, and take stock of our own journey, and take stock of a discipline which is still emerging. So in that sense, it's also a way, I think what you guys managed to do was also bring in innovation, while also trying to take sort of that longer journey of what Sarah said, from innovation and normalization. So yes, I just wanted to add that.
Thank you so much. I'm glad it worked out that way. Okay, we'll quickly have some audience Q&As. I don't see any questions in the Q&A box. So in the interest of time, if anyone's interested in asking a question, please just raise your hand, and then we'll recognize you, and then you can ask a question. Okay, while people are thinking of the questions, okay, yeah, go. Abhinav, go ahead.
Yeah.
Yes, so my question was mostly directed to what Dr. Mariam said in the beginning. She was talking about how is it even possible to have a South Asian understanding of the socio-legal, and how she did a sort of a case study of Pakistan too in her own article. And what I realized was that when we were studying the history course at NLS, which was supposed to be about South Asia, it was very focused on Indian writings. And I was just wondering if there is, if she could speak about the value of these kind of case studies from Pakistan or any other South Asian country that could help, say, an Indian student, as you said, if we are the intellectual hegemon, how can we broaden our horizon, or understand this chaos, this tension about South Asia through these kind of case studies? Yeah, just that.
Thank you so much, Abhinav. I think for one, what we're doing here is really crucial, which is to say more intentional, cross-country, cross-border conversations, not leaving it to just chance or some sort of spontaneous interaction, but really making an effort to do this. I just want to flag here that in December 2023, here in Lahore, we did our first Law and Society in South Asia workshop. And interestingly, there was a lot of self-selection in the kinds of applicants we received. And unfortunately, we had no representation from any other country other than India and Pakistan. And that was quite telling about, perhaps how people really viewed some of these forums, whether the meaningfulness of these sorts of conversations, or that there was generally a lack of precedent or apathy in terms of bringing these forums together across South Asia. And I think my takeaway really has been that you've got to create a sense of urgency and intentionality around these exchanges if you are to bring in more marginal sort of voices into the mix. I mean, I understand that, next to India, then Pakistan is probably the second most sort of talked about context within South Asia. But even so, I mean, the distance between Indian scholarship and Pakistani scholarship still is so enormous. And so it's such an uphill struggle. And I whenever I'm conceiving some sort of South Asia collaboration, I'm always so conscious about the virtuous silence that oftentimes one receives from, let's say, Maldives, Nepal, Bhutan. I mean, to quite an extent, we're able to pull in scholars from Sri Lanka and Bangladesh, and we're almost sort of perpetuating the status quo in terms of the intellectual hierarchy that exists in the region. And I think the only solution to that is what SLR is doing, and the kinds of programmatic sort of exchanges that we can have through law and society and socio-legal sort of workshops. We in the end had a hybrid format when we realized that the visa regimes were just not going to allow this to happen, and that there was no other way of bringing people together. And I realized that I was apprehensive that we had about 8 scholars from India, 8 from Pakistan, and I was a bit concerned about the people who were signing in virtually, really hoping that they would stay tuned in for 3 consecutive days. And I was just astonished. I think I was completely proven wrong, because there was so much thirst to really engage on these forums, and people just remained continuously sort of alert. They were, everybody was critically commenting on every other person's piece of work, and that really gave me a lot of hope for the fact that there's a lot of demand, there's a lot of thirst, and I think we people who are already aware of this and are engaging in forums where we're trying to bring these conversations together really need to do more of this and try and find ways and incentives of getting scholars from underrepresented sort of regions to come and join in. So I'm going to stop there, but thank you so much for that really important question.
Jyotika, I see you have a question. Would you like to ask it yourself?
Yeah, sure. Can you hear me?
Yes, you're audible.
Yeah, right. So my question is to Dr. Lhost and Dr. Surendranath for what they've said about history and criminology, criminal justice research, respectively. I'm thinking about methods and what are some useful things to think about for younger students and scholars who are interested in exploring and doing socio-legal research in these areas, specifically with respect to the question of methods. So for Dr. Lhost, I was thinking about what you were saying about questions of archives, access, and how the community of legal historians was a more fledgling sort of community, but now is growing in the kind of work that is being done. And for Dr. Surendranath, I was thinking about what you were saying about the value of theorization itself when, what you're doing in terms of research and writing is so different from what you see happening in court and what the actual response to that is. So I'm just thinking about how we can think about these issues as students who perhaps want to do this work ourselves.
Okay. Dr. Lhost, would you like to go first?
Yeah, I was just going to say, is that all right if I jump in here? Yeah, that's such an important question, especially for students, but also for people who have done work in the field. Is this question of how do you find the archive? How do you define the archive? And then when you're in the archive, or after you've defined the archive, what do you do when you're in the archive? I am the type of historian who thinks that one of the historian's job is to go out and find the sources that will not only potentially answer the questions that you want to bring to the field, but will also open up new questions. And I'm also the type of historian who thinks that there's a lot of value in sitting and reading and thinking through the sources. So I think there's a tendency among scholars, and I think this kind of goes to the theory and practice question in some ways. There is some effort among scholars to go to the archive with questions that have already been defined, and maybe even with answers to those questions that have already been imagined. And what I think makes more sense, if we're going to kind of allow the messiness or the chaos of the social to enter into the stories that we tell about the legal, there's a lot of value that comes from just sitting with those sources and allowing them to provide the stories or to provide the answers for us, rather than bringing our own stories or our own answers to the archive, letting the sources speak for themselves in some ways. In terms of finding archives, I think here's where the historian gets to be creative in thinking about what constitutes an archive, what is a source, and then whether that source is a quote unquote legal source or whether it's a social source. The historian has some creativity there. So we have sources that others have used, and we have things that have been called legal archives, or we have institutions that are considered legal institutions, and they may or may not have archives. We may or may not be able to access those archives. But historians and other scholars have the opportunity to kind of redefine what counts as the source, to redefine the questions that we bring to those sources, and then also, hopefully, to listen to those sources, to read those sources, and to come away with new answers or new perspectives that might change the way that others then go to the archive and think about those questions.
Thank you so much. Dr. Anup, maybe a short response because
yes.
we also,
Thanks, Jyotika, for that question. I would think that the job of the scholar or the researcher or the academic is to produce knowledge. I mean, and I don't think the scholar is burdened with the instrumental use of it, or should be. And I don't think that's the way higher education should go, but unfortunately that's the way it is going across the world, right, to demonstrate what is the utility of what you're producing. But I don't think that's the way we should go. And the job of strategic use of that academic knowledge being produced is one of the practitioner. I think that burden falls on the practitioner to convert that academic knowledge, research into court strategy is the job of the practitioner, I would think, right? And how to use it, how to bring it in, what will work, what will not work, is a job in that realm. So that's how I would. But may I also just make the last intervention that between the academic and the practitioner in court, also just limiting myself to criminal law and criminal justice, is how do we look at knowledge production within civil society and civil society organizations, right? And I think I would think is a separate category of knowledge production. And I think that's far less theorized, if I may say so.
Right. Thank you so much, Dr.
Right.
Lhost and Dr. Surendranath.
Thank you. So we don't have any more questions from the audience, and we also want to not stretch too much. So now we'll move to the last portion of the event, which is what we have been waiting for, at least on this side of the emails, for more than a year now, which is the launch of the special issue. So I'll just present a website. It's already live on the website, and I'll ask Divya to briefly introduce, speak about every article very briefly. Sorry, just 1 second. Is everyone able to see the screen? Sorry, I'm unsure which screen. Divya, can you confirm if?
It's currently
Okay,
blank.
just 1 second.
Yeah.
Okay, 1 second. Give me 1 second. Yeah, is it working now?
It shows that you're presenting, but I can't yet see your screen.
Can you see the screen now? The issue?
Not yet.
Okay. I don't know if it's my internet, but maybe we can give it a few seconds. It should probably work. Or maybe Divya, you can try presenting the screen if.
Yeah, I can try. Sure.
And while Divya is doing that, maybe I did want to say that while I was the one communicating over email, I do want to take this opportunity to thank all my fellow editors on the board, from choosing scholars to invite, to doing the initial student reviews, which, as some of our authors noted, is, I think, and Dr. Kalyani notes this in her postscript, that one of the peculiarities of the student-run journals, at least at NLS and with SLR, is that student editors do not only provide copy editing and other kind of feedback, but also substantive reviews. And even though there is some questioning of are students competent to do that, we have mostly received very positive feedback from our authors on student comments, of course, in addition to peer review. So I do want to thank all my editors for that, and also for all the minute copy editing, proofreading, correcting all commas and all citations for articles ranging more than 10,000 words. So yeah, I did want to thank all my editors, even though sometimes the people who are on the email and on the screen get the visibility. But yeah, so here's to all my fellow editors, some of whom are also on the call. So thank you very much. Divya, have you been able to get the thing working, or should I try again?
I've shared my screen. Are you able to see it?
Yes.
It's showing blank. Okay.
I can see the screen, Divya.
I can also see it.
Okay. It's visible? Manan?
Yes.
Yeah, do you want to perhaps okay, so with this, I think we've officially launched the issue. So these are all of the articles and all of the contributions we spoke about today. Manu, do you want to describe like the key highlights of the articles?
Sure, I thought you were going to do that. I just wanted to say that, I mean, we have 5 articles in this issue, 4 of whose contributing authors were present in the session today. Yeah, we can just quickly kind of, Divya, you can quickly go over them.
Yeah. So to begin with, we have Dr. Lhost's first article, Fingerprints and Fragments, Reflections on the Challenges and Contributions of Socio-Legal History. And as Dr. Lhost mentioned, she today examines what exactly constitutes the law's archive when doing legal history. She kind of outlines the trends in legal history and socio-legal studies to ask how a critical historian can make use of the archival fragments to situate the law within society. Moving on from history to anthropology, our second article, although the authors couldn't be present here today, by Deepa Das and Janvi Chamarti, is titled Cultivating Attentiveness to Law in India Through Legal Anthropology, where the authors essentially discuss the relationship between the discipline of legal anthropology and broader fields of law and society scholarship. Interestingly, they not only look at the Anglo-American history of legal anthropology, but they also look at some of the key concerns of anthropologists studying law in India and kind of present a really interesting overview of legal anthropological works published in SLR itself over the last 20 years. Our third article is by Dr. Anup and Maitreyi, titled The Meaning and Challenges of an Interdisciplinary Sentencing Exercise, Reflections from Death Penalty Mitigation Practice. So as they discussed in the conversation that we've had today, they kind of approach the question of social legal by focusing on both the specific problem of death penalty in India, while also drawing on their first-hand experience in representing convicts on death row. And using this experience, Dr. Anup and Maitreyi ma'am show us how mitigation practice, which draws heavily from social science disciplines like psychiatry and sociology, bring forth the sort of tensions between the supposed neatness of legal doctrine and the complexity of social reality. And our final two contributions for this issue try to reflect SLR's aim of crossing geographical boundaries by explicitly using the comparative method. So in locating social-legal research in Pakistan, a reflexive approach, Dr. Mariam deploys both a historical and comparative approach to show us the emergence and development of social legal research in Pakistan, and doing so, she compares that with India as well. And she argues that the meaning and evolution of the socio and socio-legal is contingent on context, both social and historical, and kind of concludes by saying that the challenge for social legal scholarship in South Asia is to move beyond themes that are state-centered. And finally, we have the article authored by Dr. Desley titled Social Legal Inquiry on a Global Scale, Legal Intermediation, the Geography of Extraction, and the Renegotiation of Africa's Relationship with the World Economy. In this piece, Dr. Desley asks what a social legal inquiry can tell us about one of the most pressing problems of our time today, which is climate change. She makes use of the global turn in the social sciences to show the readers of how the law is entangled in selective social and financial and cultural globalization fostered by global value chains, with the example of cobalt in the Democratic Republic of Congo. And doing so in her piece, she privileges the vantage point of Africa, opening to us a possibility of thinking about the global from a subaltern position. And finally, we have the postscript by Dr. Kalyani as well. Manhar, do you want to talk about the postscript?
Yeah, this is something we really wanted to do. As I already said, Dr. Kalyani was the editor-in-chief of SLR in 2007, volume 3. So invited her to reflect on how the field has evolved and from her own experiences of working at SLR. And I would recommend everyone to read this postscript where she talks about the institutional conditions at NLSIU, which led to the foundation of SLR, the conversations which happened with the critical legal studies movement in the UK, the questions which the then editorial board asked, and she ends this postscript by giving us 3 things to think about the future of social legal scholarship as we look ahead. And with that, we come to the end of it. The end of the event. Once again, I want to extend my heartfelt thanks to all the authors for accepting our invitation to write, for being so patient with us, for responding so positively to peer reviews, and for making your time to attend this event today. I also want to thank all the peer reviewers, editors, our faculty board, the university, and the consulting editor at the university. Last thing I wanted to say is that since we're a student-run journal, one of our aims in doing this anniversary issue, I mean, usually journals have 25th anniversary issue, but we thought that we really wanted to make use of this opportunity of 20 years, also in order to increase the visibility of SLR and the work which SLR has been doing. We often do not get enough great articles from established scholars in the field because there's a perception that somehow perhaps student-run journals are not at par with established journals in the field. So I would also invite all of you, if you like our work, to share it with your colleagues, friends, students across the globe. Yeah, thank you very much for joining us today.